on the docket. Okay. I love technology. Anyway, this is the Zoom docket. Ordinarily, we would live stream this on the court's website. We've had some technical problems with that. So what we are doing is recording this argument to computer, and we will post it on YouTube later. So we are not streaming live to the outside audience. And it's technology that's way beyond me, and we haven't been able to do that. Let me introduce the other judges on the panel. We have Judge Steve Hill, who is now the longest serving judge in Kansas. Also with us today is Judge Amy Klein, who joined our court about 3 months ago, but is not the least tenured of our judges. We have 2 newer judges as well. And I'm Gordon Atchison. I'll be the presiding judge, which means I keep the time for today's argument. I fall between the 2 of those, much closer to Judge Klein in tenure. I just passed my 10th anniversary with the courts. The case we have in front of us at the moment is Moore Trust, John Moore trustee versus Jebediah Moore and Stephen Moore. This case has been set for 15 minutes of argument. And the appellant may reserve a portion of that for rebuttal. And Mr. Ong, at the start of your argument, if you would let me know how much you wish to reserve, we will do that. And, I will advise counsel. Of course, we've read the briefs and are generally familiar with the case. And with that, Mr. Ong, you may proceed.
Oh, yes, and I would like to reserve actually 5 minutes of my time.
You have it.
On rebuttal. So on behalf of the Moore Trust, we are the obviously welcome actions of the panel at any time on any of the matters covered in our brief, but in the time I have here, I was going to focus on basically 3 matters that I think are the most obvious ones that call for a reversal of the ruling of the trial court. And these roughly follow issues. The primary one, which is count of our brief, is that the trial court just failed to follow the mandate of the prior Court of Appeals actually directions on what the trial court was to do upon remand. And specifically, the prior panel in its mandate directed the district court to apply a 4-part test in evaluating the undue influence cause of action, and that's the timing, the motive, the pressure, and the relationship of the parties, and that was a direction of the court in its mandate, but that isn't actually new law from the prior case. That goes back. The prior case quoted the Frame case, but those elements have been part of Kansas law for about 80 years, going back to a case I think in 1931. It's very clear from just the face of the trial court's ruling that it didn't apply any of those elements. There's a recitation that the court was going to apply the mandate, but it in fact did not. And the law in Kansas is really clear that when a mandate is issued, a trial court is to apply both the letter and spirit of the mandate. And here we have neither one. And And that alone, I think, is a cause for reversal. In our count two, we went through really the undisputed facts of the case that the district court in its ruling just frankly got wrong. The main one that we focused our time on in our brief is the court's finding that the attorney that drafted the contract was in fact acting in a role as the attorney for Joyce Moore. And that was very clear in the court's ruling to satisfy their requirement under Kansas law that actually Joyce Moore had independent legal advice.
Counsel, let me ask you a
It's
question.
very clear that
I wanted to explore the significance of whether or not this lady was represented by counsel. Why is that important under the facts of this case? And there was an attorney there, but how is it that you say that the court got it wrong? Could you explain that to me?
well, in fact, Kansas law. Well, first off, we're in a contractual undue influence case, and even if you look at the jury instructions, I'm kind of well aware we're in a trial to the bench case here, but even in the jury instructions for an undue influence contractual case, the primary defense to that allegation is, did the person adversely affected by the contract have the benefit of independent legal advice? And if a person entering a contract, whatever the terms are, had the benefit of independent legal advice, that's a strong defense to a undue influence allegation. Here, there was an absence of any advice to Joyce Moore, and in fact, the attorney who she said she thought was her attorney adamantly denied that it was her attorney, adamantly denied that he owed any duty to her, and in fact, testified under oath and basically pled when the law firm was part of the case that they owed no duty to her, and that they were instead the attorneys for the other party to the contract. So I think it's really significant. I think it's in fact dispositive of the case that actually Joyce Moore had no advice, and in fact may have been misled when she thought she had an attorney actually looking out for who was in fact owed a duty to the other party.
Is your view then that this is dispositive, just the fact that she did not have counsel?
Well, I think it's dispositive of it goes to, it was one of the key things that the district court found in favor of stating that the appellees in this matter had overcome the presumption of undue influence. It was her express finding that they had overcome the burden because Joyce Moore was independently represented by Don Cashman. And I think if you cut that leg out of the district court's ruling, the entire ruling falls. Yes.
Thank you.
You've suggested.
In another.
Yeah.
You
suggested that
going this morning. So I called you, Lloyd Zisco, and he tried a bunch of stuff. He couldn't get it to work.
James, we're picking you up here.
Your microphone's on, James.
That's the gremlins at work. Mr. Ong, you suggested in your brief that the burden on Stephen and Jebediah to overcome the presumption of undue influence is by clear and convincing evidence. If in fact the burden is a preponderance of the evidence, as the district court suggested, what happens to your case?
Well, I guess I'll take that in two parts. The district court did apply a preponderance of evidence standard, and that is very clearly the wrong standard in this case. It is the higher standard of clear and convincing evidence. I think if Mr. Fresh acknowledges that is a proper standard, but under the preponderance of evidence, well, but I would say even if we use the wrong standard, the lower standard, still there was not evidence that supports a court's finding on that. The terms of the lack of independent advice, as I just discussed with Judge Hill, combined with the egregious terms, and also I think the other dispositive thing, which is count 3 of our appellate thing, is a fiduciary, and we recognize Stephen Moore was a fiduciary towards Joyce Moore, is required to act in good faith. And that is that's been part of Kansas law for 100 years in contractual. When a fiduciary is contracting with their principal, the requirement is that they act in good faith, which means for fair consideration, for fair terms. And the trial court did not address the good faith issue at all. And in fact, we say it's very clear on the face of it that if the good faith standard is applied, there's no way the contract survives. So I'd say even under a preponderance of evidence standard, the lack of independent legal advice and the lack of good faith are fatal to the appellee's case.
Okay, thank you.
I have nothing further.
Okay, well, you're about to go into your rebuttal time in any event, so unless we have other questions, we'll turn it over to Mr. Fresh. You have 15 minutes.
Thank you, Your Honor. May it please the court, John W. Fresh for the appellees, Stephen Moore and Jebediah Moore. Good morning. I guess I would like to maybe respond first to some of the issues that were raised in the reply brief filed by the appellants. They say that we misconstrued their arguments in our brief insofar as they were arguing that the court's findings, the trial judge's findings, weren't supported by the evidence. And we very clearly believed the court's findings were supported by substantial competent evidence. And I think that the issue, and I think what they did in there.
Well, let me stop you right there, counsel. What evidence is there that Joyce was represented by counsel? What evidence is there in the record that demonstrates Joyce was represented by counsel?
Your Honor, the evidence in the record would be that Joyce was familiar with Mr. Cashman. She talked to Mr. Cashman after the contract was signed. She called him and wanted to make a change to it. So she considered that he was assisting her. She certainly had access to talk to him. Nobody ever prevented her from speaking.
So she signed it before she talked to an attorney. Am I understanding the facts correctly?
I don't believe either contract was reviewed by Mrs. Moore or her husband with an attorney before they were signed. But
how could the court then conclude that she had competent counsel's advice prior to executing, signing the document, if she didn't consult until later? I mean, it's a fait accompli then, is it not?
She was not prevented. She wasn't prevented from asking questions. She could have asked the attorney questions about the contract.
And I'm not talking about her actions. I'm talking about the court's finding that she was represented by counsel, that she got counsel's advice. And it seems to me that for that to qualify, it should be done prior to signing the document, would it not? I mean, afterwards, it's a done deal, isn't it?
Well, once it was signed, Your Honor, well, I guess I would respectfully disagree. It's a done deal since we're here. We've been fighting this case for 3 years. So apparently it's not necessarily a done deal. but she was never, there's nothing in the record that says she ever had a private consultation with any attorney regarding the contracts.
Okay.
But there's also nothing in the record that says she was prevented from doing that, because there's no evidence that she was prevented from doing that. And two, there's no evidence that she wanted to do that. She never said, I want to take this to a different attorney, or I want to meet with an attorney privately to discuss this. She never brought that up.
But in these issues where we're talking about possible undue influence, the burden is upon the person who has received the benefit of this to show that there is no undue influence, correct?
Correct.
And one of those tests that we look at is whether or not they have counsel. And if this woman had no counsel, how do you survive that? How do you show that there's no possibility of undue influence?
I think you have to balance that against all the other factors involved in the case. I think you have to balance that against the totality of the evidence and everything else that went into this, that went into the formation of these agreements, that went into the execution of these agreements, that went into what was carried out after the agreements were made. I think you have to look at that totality. This was a person who was not unsophisticated. They may want to portray her that way, but the evidence, there was plenty of evidence at trial that was contrary to that. This was a person who was in control of her faculties. There's no evidence that she wasn't. They had a doctor who looked at old medical records and made some comments at least about that the first contract on the house. But again, the trier of fact was free to put whatever weight they wanted to on that evidence. This was a person who had discussed with her now deceased husband, but discussed with him when he was alive, and who acknowledged at trial, Mrs. Moore acknowledged at trial that it was always her and her husband's hope and desire that the farmland would stay not only in the family, but would be farmed by a family member. And they knew the evidence was the only logical person to do that was their grandson, Jeff. And so she was carrying forward that desire that her and her husband had had. And that had been discussed long before these contracts ever came up. And so I think you have to weigh that against, did she have an attorney? Again, she wasn't deprived of access to an attorney and never said, wait, I want to have an attorney. Nobody can force somebody to go and get separate legal advice. I have people that come in to sign a prenup and I say, you need to take this to an attorney. I can't force them to do that. I would like them to do that.
In this case, what does the record show about who supplied the terms of the contract to Cashman before he wrote it up? What's the evidence on that?
I believe the information was given to Mr. Cashman of the terms either by Stephen or Stephen's wife. And again, the trial judge didn't find that unusual because Stephen was the one that was able to be out and about. I think she says in her memorandum, he was not ill. He was able to move about. I mean, I don't think that's really all that.
Okay.
Untoward.
The other question I have, it seems as if the district court made a finding of fact that within several days after signing the contract, I think it was on September 9th was when it was signed, Joyce called Cashman and said, I want to undo this. And he told her they couldn't do that. Did the of that to that effect? And if so, how does that play into the whole scenario of undue influence?
Your Honor, I think actually the finding was actually that she contacted Cashman that did not ask him to undo it. I think the court put some weight on it. What she asked Mr. Cashman to do was she wanted to modify the terms to that if Jebediah sold the property within 10 years, that he would share the profits with other family members. And Mr. Cashman said to the effect they couldn't do that unilaterally, but he would reach out to those other parties and see if they would agree to that. If they would, it could be done. So I think that was the judge's finding. And I think the significance of that, Your Honor, as it relates to undue influence, would be that it shows that Joyce Moore was conscious of the terms of that contract. She was conscious that it was a good deal for her grandson. She was conscious that there could be profit to him. So she understood those things. And the fact that she didn't want to completely undo the transaction shows that it was her free will and intention. I think what's being overlooked here when we talk about undue influence is what undue influence is. And the case law defines it roughly as substituting your judgment or desire for the person actually doing the act. And I think, frankly, I think that's a pretty steep hill to climb. I don't think that just because the transaction is favorable, more favorable than it would have been if it was a stranger off the street, I don't think that shows that Steve Moore's or Jeb Moore's will or intention was substituted for Joyce Moore's. In fact, there was testimony at trial, which again, the trial judge was free to believe that this was a person who had her own mind and made her own decisions and was not easily convinced. So I think the court was free to take that testimony, take that evidence, and put whatever weight she wanted to with it, and she did.
Counsel?
Go ahead.
Well, I just wanted to follow up on that finding because I recognize the court found it notable that Joyce did call later and asked to make changes to the contract. Couldn't that also indicate that she was caught a little flat-footed in the lawyer's office where, you know, Steve and the lawyer presented her with a contract that she'd never seen and they had drafted up? The fact that maybe she's now sinking in a little bit later and she's finally realizing what happened. I mean, couldn't that evidence indicate that she wasn't prepared that day at the lawyer's office just as much?
That would be one way to read it, Your Honor, but I think another way, and again, in the testimony at the trial, the testimony was that after the contract was done, Mrs. Moore started to have second thoughts, whatever, because she was afraid her other children were going to be mad at her. And so there's conflicting testimony for Mrs. Moore and Stephen Moore about that. There's conflicting testimony. Mrs. Moore said, well, Stephen told me not to tell my other kids. Stephen says, she told me not to tell my siblings because she didn't want them to be mad at her. And so I think the other way to look at the point you just made is that she started to be concerned about how those other children were going to react. And so she was looking for a way to maybe placate them in the future that, well, okay, I did this, but if he sells it, then you're going to share in those profits. And again, the issue there is, if you believe the testimony of Mrs. Moore saying, Stephen told me not to tell the siblings, or Stephen Moore saying, Mom told me not to tell the siblings, you have to make that credibility determination to go down that road. And again, the trial judge was in the best position, and at this stage, the only position to make that judgment. So, and it fell in favor of Stephen. And so I think the rest of it flows from that.
And Stephen and Jebediah didn't agree to make that change, did they?
Actually, I think I read something somewhere in this that they were agreeable to that. It was just never done.
Well, I think what the judge found was that Jebediah testified he had no objection to that because he wasn't planning to sell. Cashman testified that he twice contacted Stephen and asked him about it and got no response. So it didn't ever happen.
That's right, Your Honor.
And that's what's in the
memorandum.
findings.
Yes.
I wanted to ask you, Mr. Fresh, what you think the burden of proof was on Stephen and Jebediah to overcome undue influence, and does it make a difference to our analysis whether it's a preponderance of the evidence or clear and convincing evidence?
Your Honor, on one hand, I guess I have to have faith in the trial judge that she knew the law and applied the right standard. I know in my brief, and Mr. Ong points out that I agreed with his assertion that there was a different standard. I think in his maybe reply brief, he refers it, and he doesn't call it clear and convincing, he calls it something else. I think if the court applied the wrong standard, I think the matter would still have to be remanded to her to apply the correct standard and make a new finding. And I understand that changes things, but I think that's the remedy. I don't think that this court, with all due respect, can just say it's a higher standard, and so we're just going to throw this out and completely turn it around. I don't think that would be appropriate, because then you'd be substituting your application of the evidence and the weighing of credibility and all that to the case.
Mr. Fresh, you're just about at the end of your time. If you want to take a minute and sum up for us.
Thank you, Your Honor. Yes, I do think that, first of all, I don't think that the trial judge was required to articulate every individual thought she had in reaching her decision. She was required to apply the law, the four factors that Mr. Ong stated. I don't disagree with that, but I think she did that. I think that's inherent in her decision. I think the decision is supported by substantial competent evidence in the totality of the circumstances. And again, to reach that substantial competent evidence, you have to weigh the evidence, and you have to determine credibility and determine the weight to give to conflicting evidence. As I said before, you had a 180-degree testimony about who said not to tell the siblings. And so somebody had to make a decision. The judge had to make a decision there. The last thing I would say, Your Honors, is the remedy that they've requested in this is basically just handing the verdict back to the plaintiffs, and I don't think that's available. I think that, and this is in the Dragon versus Vanguard Industries case, which I think I cited in my brief. I think the remedy is to remand it to the court, to the trial judge, to make additional findings and articulate more legal conclusions. So if that's what has to, if it's going to be reversed, that's the remedy, is to remand it back to that judge, not for you to substitute your judgment for her. Thank you.
Any other questions for Mr. Fresh before I turn it back to?
No.
No
Thank you.
question.
Mr. Ong, you have 5 minutes.
Well, a couple points from Mr. Fresh's argument. This is not an issue of the appellate court substituting the judgment of the trial court on weighing issues of credibility. I mean, the testimony of Don Cashman was very clear. He was not Joyce Moore's attorney. He never acted as Joyce Moore's attorney during this whole entire process. So that's not a credibility issue. I mean, that's the testimony of Don Cashman himself, that he did not provide any legal advice to Joyce Moore. Awkward for him is that he had been the longtime estate planning attorney for Joyce Moore and her husband, John, And he was the one who drafted their revocable trust that included an option for Stephen Moore to be able to purchase this farmland to keep it in the family upon the death of Joyce Moore. Stephen Moore just had to pay fair market value. So this entire contract was a way to undermine the longstanding estate planning objectives of John and Joyce Moore to at least provide an opportunity for the farmland to be kept in the family. Stephen Moore, Jebediah Moore just didn't want to pay fair market value. So this contract was put in place without legal advice. But importantly, because Stephen Moore was the fiduciary power of attorney, the duty of good faith applies to that contract. If he's going to transact as an agent for his son Jebediah, the contract is required to be done in good faith. And as we quoted in our brief, Kansas law is pretty clear in a contractual good faith element. It's got to be fairness in fact, honesty in fact, a commercially reasonable and adequate transaction. Here we had
Mr. Ong, I question, up to this point, meaning on this appeal, had you separately pursued a claim based on a lack of good faith? And if so, where do we find that in the record?
Well, I mean, good faith is an element of a undue influence cause of action against a fiduciary in a contractual case. So and I think the Kansas cases on that, case law on that is very clear. It's subsumed into a cause of action for undue influence by.
Okay, I mean, based on looking at
it's the burden.
Based on looking at, for example, the terms of the contract itself, and whether that's reflective of fairness or undue influence. Is that what you're suggesting?
Right.
Okay.
Right. And remember the burden is basically shifted on the person benefiting from the contract. The burden is on them to show good faith. The burden is on them to show the fairness of the terms. And here, it's measuring credibility of anybody. It's looking straight at the contract terms. $1.4 million of real estate left the trust, replaced by $5,000 cash and a promissory note payable over 30 years. Joyce Moore would have been 110 when, and the price to be paid was 20% of the fair market value. So 1.4 out, $5,000 cash in, and the balance at an 80% discount paid over 30 years. That, as a matter of law, this court can find that's not good faith and that's not adequate consideration.
Counsel, is your argument on that point tempered by the meeting with the banker? It's my understanding that the court interpreted the meeting with the banker to address the fair market value argument with respect to the property in all the conversations about, the cash flow and what the farm could actually support in terms of a price. Did I misread the record in that regard?
I believe that the testimony of Del Elfner, it was that Joyce Moore sat quiet the entire meeting, did not say a word. He implied that she might have understand what was said, but she didn't ever say a word. So there's nothing affirmative that shows that Joyce Moore even understood what was going on. I think, and I believe we quoted some of the testimony of Del Elfner in our brief to that effect.
So it's your position, just because she didn't ask a question, she didn't know what was going on?
Well, I think when you have a woman in her 80s not represented by counsel who is brought to a meeting and never asked a question, and I don't know if a question was even put to her, I'll have to go back and look at it. She was just brought as an observer into a room. I don't think that burden that is required in a case like this, the burden being on Stephen and Jebediah Moore to show the adequacy of the terms. So I think her silent person attending a meeting, I don't think is overcomes the standard of proof that is
So you're
imposed
saying
on the
then,
appellees.
you're saying then it is the burden upon them to show that she understood. It's not the burden upon you to show that she misunderstood.
I think Kansas law is very clear when in a contractual undue influence case, once we establish the fiduciary relationship, the contract is presumed to be tainted. The contract is presumed to be subject to rescission. The burden then falls upon the fiduciary to establish these terms, to establish independent legal advice, establish the contract was done done in good faith. That's their burden, and they, as a matter of law, did not meet the burden because of the undisputed evidence of Cashman. And then you can just basically look at the contract on its face. It is not. There's no way that contract actually meets the standard of good faith and fair dealing that is required in a contractual case. I would say that
I would
as a
say,
matter of law.
Mr. Hong, I would say you've gotten to the end of your time unless there are more questions. We're going to wrap this up.
Okay, Your Honor, I just say in terms of what we'd want the panel to do, we think the law on this matter is clear, and this court can enter an order rescinding the contract, finding it void as a matter of law, and then the parties would just be remanded to deal with on the end.
Thank you very much.
Thank you.
We will take the matter under advisement and get out an opinion as soon as we can. I appreciate the briefs and the argument of counsel here today. It's been very helpful. Thank you.
Thank you.
Thank you.